Good afternoon, everyone. My name is Brian Kleinbord. I'm the chair of the Criminal Law and Practice section of the Maryland State Bar Association. Thank you all for joining us today. I think we have a really good turnout for this webinar, and it promises to be very practical, hands-on, very useful training from really the foremost experts on the subject. So this is Maryland Sentencing Guidelines 101. I know this is something that criminal practitioners use on a daily basis. And I'm very happy to welcome our two presenters for today. And I'm just going to briefly introduce them and then turn it over to them so that they have as much of the hour and maybe a little bit beyond an hour to do their presentation. Before I do that, I just want to thank Rick Fincy, who is an ex officio member of the criminal practice section, for his efforts in helping to coordinate this program, and also Angela Monroe, who really has done all the hard work in putting this together. Angela is our liaison with the Maryland State Bar Association, and everything you see here that is not the work of our presenters was really thanks to the hard work of Angela. So let me introduce David Soule and Catherine Pembroke. Dr. Soule has been the executive director of the Maryland State Commission on Criminal Sentencing Policy since 2004, where he leads the agency's efforts to develop and implement the state's criminal sentencing guidelines. Dr. Soule has presented at a variety of national and state conferences, including the National Association of Sentencing Commissions, the American Society of Criminology Annual Conference, and the Society for Prevention Research, and the National Sentencing Policy Institute. Dr. Soule earned both a PhD and an MS degree in criminology and criminal justice from the University of Maryland, and he was elected as a member of the executive board of the National Association of Sentencing Commissions in 2008, and served as vice president for that association for 2 years. Welcome, Dr. Soule. And also joining us today is Catherine Pembroke. Catherine is the administrative and training coordinator for the Maryland State Commission on Criminal Sentencing Policy. In that position, she oversees the daily administrative duties and provides training on the sentencing guidelines to criminal justice practitioners throughout the state. In addition, she oversees the MAGS system, the Maryland Automated Guidelines System, and regularly responds to inquiries from practitioners. I'm sure many of you who are participating today, to ensure the proper application of the sentencing guidelines and the successful operation of MAGS, which I know is a huge responsibility that we are indebted to you for. So thank you. I turn it over to David Soule now.
Thank you, Brian. Appreciate the introduction and welcome everyone to this webinar today. I do want to just quickly echo Brian's appreciation and thanks for Angela for helping us set up this webinar. We are really appreciative of the opportunity to speak with this group. I will keep my introduction brief, and Catherine really will handle the lion's share of the presentation today, and you are in excellent hands with Catherine. I just really wanted to point out that the sentencing guidelines play a significant role in supporting fair and proportional sentencing policy in the state. So participation in trainings like this and staying up to date, on the sentencing guidelines is really important because it helps to promote the consistent application of the guidelines. And if you're here today, that's really what your goal is, and we appreciate that. And as Brian noted, if you've emailed the commission or called us, you probably already communicated with Catherine or Stacy or Sarah, who are also on this webinar today and will be helping me monitor questions in the background. We're a small staff, that's it, that's all of us. But we want you to know that we are here to help you, and we appreciate and certainly welcome any questions you have. So we may not be able to get to them all of them today during this webinar, but please know that you can reach out to us at any point after the webinar. Our contact information is available on the last slide of the presentation, and we look forward to today's training and look forward to your questions. So I will now turn you over to Catherine, and while myself and Stacy and Sarah monitor your questions in the background. Thanks again for joining us.
Thanks, Dave. Welcome, everyone. We're really happy you were able to join us this afternoon. So as Dave said, this is going to be an incredibly informative webinar. So whether you're new to calculating the sentencing guidelines, or maybe you've been utilizing them for quite some period of time by now, hopefully you'll walk away from this training just feeling more comfortable with guidelines calculation and maybe even learning something that you didn't know before. So before we get started and jump into it, I just want to quickly go over some general webinar housekeeping. I'm sure many of us are very familiar with Zoom at this point, but in case we have some people who may not be, I just wanted to point out a couple of icons. So we are asking participants to remain muted throughout the course of the presentation, just to ensure that we get through it in a timely manner. So if you look to this little mute icon, you'll want to make sure you see a little red slash through there. If you want to turn on or off your video, you could just click that stop video button. As Dave mentioned, we do want this to be an interactive webinar, so please feel free to ask questions through this chat box throughout the course of the webinar, and one of our staff members, either Dave or Stacy or Sarah, we'll get back to you. We definitely encourage you to submit your questions to the whole group, just so everyone can benefit from seeing the question and the answer. But that said, if you don't feel comfortable submitting your question to the whole group, that's fine. We just ask that you submit the question directly to either David Soule, Stacy Najaka, or Sarah Bowles. If you submit it to me, I'm probably not going to be able to see it until the very end, since I'll be taking the lead on presenting this presentation. In the chat box, you should also see two PDFs. The first is basically a handout of this presentation, so it'll show you all the PowerPoint slides from the presentation for today. The second handout focuses on forthcoming changes regarding guidelines compliant pleas that will be going into effect on April 1 of this year. We're going to be talking about that in much greater detail towards the end of the presentation, but that's a really helpful document. So I encourage you to save them to your computer, print them out. I believe these will also be uploaded to the MSBA website as well. So just wanted to point those out. Okay. Let's move forward with the agenda for today's training. So since most of you are probably somewhat familiar with the guidelines at this point, we thought it'd be helpful to start the presentation by providing some information about the background and goals of the Maryland State Commission on Criminal Sentencing Policy, commonly referred to as the MSCCSP. Then we're going to get into various sections of the guidelines worksheet and how they should be calculated. We're also going to look at some special applications that adjust the calculation of the overall guidelines. And throughout the course of the presentation, we're going to be focusing on recent updates, guideline-specific updates that have been implemented over the past couple months, with a specific focus on these revised instructions regarding guidelines compliant pleas that will be going into effect on April 1. So let's go ahead and get started here. Let's begin with a brief history of the guidelines and the Sentencing Commission in Maryland. So Maryland was actually one of the first states to initiate a sentencing guideline system. The guidelines were first introduced by the judiciary. In April 1979, the Sentencing Guidelines Advisory Board, which was formed by the judiciary, approved a system of voluntary guidelines to be piloted in 4 jurisdictions. These sentencing guidelines were then approved for statewide use in the circuit courts starting in 1983. The guidelines in Maryland were in effect statewide for 15 years with oversight by the judiciary. And then in 1999, the legislature decided that a permanent independent sentencing commission should be created to have oversight over the guidelines. And thus the MSCCSP was born. So the enabling legislation that created the current day Sentencing Commission outlines a statement of intent for the MSCCSP in Criminal Procedure Article Section 2-202 that includes 6 goals. First, that sentencing should be fair and proportional, and that sentencing policy should reduce unwarranted disparity, including any racial disparity, in sentences for criminals who have committed similar crimes and have similar criminal histories. Second, that sentencing policy should help citizens to understand how long a criminal will be confined. Third, sentencing policy should preserve meaningful judicial discretion and sufficient flexibility to allow individualized sentences. Fourth, the sentencing guidelines should be voluntary. Fifth, the priority for the capacity and use of correctional facilities should be the confinement of violent and career criminals. And finally, that sentencing judges in the state should be able to impose the most appropriate criminal penalties, including corrections options programs for appropriate criminals. Now, the Commission has a few primary responsibilities to help address these goals, with the first responsibility being to implement and maintain the state's voluntary sentencing guidelines. And this is accomplished through the second major responsibility, which includes the collection and maintenance of an extensive database, which is compiled via the data that's submitted on the sentencing guidelines worksheet. So the Commission uses the guidelines data to monitor circuit court sentencing practice. The Commission also examines sentencing patterns and reasons for departures for specific offense categories and within individual cell ranges. And by doing so, we're able to consider adopting changes to the guidelines when necessary. And finally, the Commission is responsible for providing training and orientation to criminal justice practitioners to promote the consistent application of the guidelines and the accurate completion of the sentencing guidelines worksheet. So just to give you an idea of who exactly makes up our commission, the MSC-CSP is an independent, objective agency comprised of a balanced and diverse group of 19 criminal justice practitioners from all three branches of government. The commission is currently chaired by Judge Brett R. Wilson, a circuit court judge in Washington County. The membership also includes 3 additional judges, including representatives from each of the 2 trial courts and 1 appellate's court representative who serves as the chief judge's designee. The remaining 15 members include a cross-section of criminal justice officials from the other 2 branches of government, as well as 2 public representatives. The MSC-CSP makes decisions with respect to the guidelines after deliberating with the many stakeholders that comprise the Maryland criminal justice system, most, if not all, of its constituencies being represented here on the commission. So let's get down to the basics. What is the purpose of the sentencing guidelines? The sentencing guidelines are a mechanism to encourage proportional sentences. Now, the primary goal of the guidelines is to promote consistent, fair, and equitable sentencing practices, whereby offenders who are convicted of similar offenses and who have similar criminal histories, they're being treated and sentenced alike. The Maryland sentencing guidelines were designed to systematically account for the most common variations in offenders and their offenses. They help to achieve proportional sentencing by identifying and assigning weights to core objective factors for consideration by judges in making sentencing decisions. The guidelines account for the most common, but certainly not all, characteristics of an offender and his or her crime that are most relevant to the sentencing decision. And they help to provide a framework to allow judges to consistently assign the same value or score as their colleagues around the state for each of these legitimate legal factors. So let's take a look at some of the other basic principles of the sentencing guidelines. That being that they're voluntary, so judges may at their discretion depart from the guidelines. They're also intended to be primarily descriptive, meaning that the guidelines should be reflecting how judges are actually sentencing, and they may be amended when the data indicates that sentences are not consistent with the recommended ranges. Finally, the guidelines are generally limited to cases that originate in the circuit court, so the guidelines do not apply to district court cases. Jury trial prayers and appeals from the district court, they are guidelines eligible, but only when a pre-sentence investigation is ordered, which is a small percentage of those cases. Next, let's discuss how the guidelines data are utilized after sentencing to help inform policy decisions. So generally speaking, the data is assessed to review sentences and helps to inform the commission whether changes to individual cell ranges or offense seriousness categories are warranted. The data are also used to monitor compliance and to see how often judges depart from the guidelines for specific offenses and offense types. And finally, the data is also used to inform the legislature of sentencing patterns for specific offenses or offense categories. So every year we actually publish an annual report detailing various sentencing trends throughout the state of Maryland for a given fiscal year. So all of these reports are published to our website if that would be of interest to you, we certainly encourage you to access them via our website and check them out. So next we're going to start getting into guidelines calculation. And before we jump right into it, I want to start by defining criminal events for guidelines calculation purposes. So a criminal event is defined as one or more crimes committed in the course of the same transaction. Whereas a multiple criminal event means that more than one criminal transaction was committed over a period of time. Now, multiple criminal events being sentenced together, they may have occurred on the same date or different dates, but generally offenses that occur on different dates are almost always considered separate criminal events. Next, let's discuss what constitutes a sentencing event. So a sentencing event is a sentencing disposition or hearing for an individual defendant conducted in front of one judge on the same day. So when you have multiple criminal events that we just discussed, if they're being sentenced by the same judge on the same day, they constitute one sentencing event, meaning that one set of sentencing guidelines should be completed for each sentencing event, which would result in one overall guidelines range. Just want to note here that for guidelines calculation purposes, merged offenses are not included on the worksheet and do not factor into guidelines calculation. So let's take a look at what a multiple criminal event, single sentencing event scenario looks like. And I know the text is small in this screenshot here, so just bear with me. But here we have two criminal events sentenced in front of the same judge on the same day. If we look to this this worksheet in the upper left-hand corner, you can see we have a CDS distribution, PWID manufacturer, et cetera, of PCP. That occurred in July of 2020. It has its own unique case number ending in 4001. And then in the bottom right-hand corner, we have an assault first degree that occurred a couple of months later in January of 2021. Again, has its own unique case number. And we can see they're both being sentenced on May 4th of 2021 in front of the same judge, Judge Thomas Johnson here, meaning that they constitute one sentencing event. Now, by guidelines rule, each separate criminal event should correspond to their own guidelines worksheet. So even though we only have one convicted offense per criminal event in this example, it's still correct that they're corresponding to their own guidelines worksheet. So each worksheet has its own individual guidelines range calculated for the convicted offense. However, there is still one overall guidelines range calculated between the criminal events since this is one sentencing event. So that's just a basic example of how a multiple criminal event, single sentencing event scenario should be initiated and reflected on guidelines worksheets. So the next section of the guidelines worksheet that I want to discuss is the convicted offense information, which is pretty self-explanatory. The information that you see highlighted here relates to the convicted offense information, beginning with the date of offense, and then jumping down to this language that we see here that says at this sentencing, the number of convicted offenses and criminal events. Now, I want to note whether you're officially initiating worksheets in MAGS, our automated guideline system, or perhaps running sample guidelines using our guidelines calculator tool, which I'll talk about a little bit later. You want to make sure that you're entering the proper number of criminal events as well as reflecting the proper count numbers correctly to ensure that these numbers in the upper left-hand corner are populating accurately. For those of you who may remember prior to MAGS, when these worksheets were manually calculated, we know that the number of criminal events in particular greatly affects how the overall guidelines range is calculated. So it's very important when you're just reviewing worksheets or calculating your own guidelines that that number is reflected accurately. Now, jumping down to the convicted offense title, again, whether you're using MAGS or running sample guidelines in our guidelines calculator tool, based on the offense that you select, the convicted offense title, the CJIS code, the statute, the statutory maximum, if there were a mandatory minimum, that would populate here, and then the case number corresponding to the convicted offense populates here. Now, the last column I want to talk about in greater detail is right here. It has the Roman numeral equivalents of 1 through 7 as the header, and that's the seriousness category column. So I'm going to divert from the worksheet for a second to talk about why that's a critical component to guidelines calculation. So most of you are probably familiar with the general framework, but I just want to give a brief overview of the basic premise of the guidelines. So Maryland has 3 separate sentencing matrices. We have one for property that you see here, we have one for drug offenses, and then one for person offenses, those offenses which typically involve victims such as assault or robbery, as well as weapon-related offenses. Now, the guidelines were designed to take both offender and offense characteristics into account. So looking to this property matrix here, we can see that the first column represents the offense seriousness category column. Now, each guidelines eligible offense in Maryland is ranked based on its seriousness, with 7 being the least serious to 1 being the most serious. And for property offenses, we can see that those seriousness categories range from 7 to 2 being the most serious. And looking at the top, we can see that the guidelines range for property offenses is then derived from a combination of the offense seriousness category and the offender score, which we'll talk about in greater detail later. But that captures basic components of an offender's prior criminal history. So let's just walk through a basic example. Let's say we have a defendant who was convicted of theft less than 100, which is a seriousness category 7 property offense. And let's say they have no prior criminal history, so an offender score of 0. So if we look to this property matrix here, we can see that the recommended guidelines range would be probation to 1 month. And again, that's just a basic example of how the guidelines are calculated. And again, just helps to highlight how important and critical the offense seriousness category is to guidelines calculation. So jumping back to the worksheet here, the next section we're going to discuss is the offense score section. Now, the offense score applies to person offenses only. I mentioned earlier that those typically involve victims such as assault, robbery. They also include weapon-related offenses. Now, the offense score is a summary scale ranging from 1 to 15, and it measures the seriousness of a person offense based on 4 components. And we're going to look at each of these components in more detail. We have section A, seriousness category, B, victim injury, C, weapon presence, and D, special victim vulnerability. So beginning with A, the seriousness category. If we look to this chart here, we can see that X number of points are awarded just based on the seriousness category of the underlying offense. This ranges from 1 point for seriousness category 5 through 7 offenses, all the way to 10 points for seriousness category 1 offense. Now, in general, any attempt, conspiracy, solicitation, or accessoryship to commit a given offense is going to be assigned the same seriousness category as the underlying offense, unless specifically addressed by a separate statute or placed in a different category. Now, exceptions to this general rule come into play with some of the more serious offenses. For example, first-degree murder is a seriousness category 1 offense, the most serious offense possible, whereas attempted first-degree murder is a seriousness category 2. And the same is true with rape. So again, some of those more serious offenses may have a difference in seriousness category depending on whether a conspiracy, attempt, solicitation was involved. So if you ever have a question about the seriousness category, you can always refer to our guidelines offense table, which is a searchable PDF available on our website, as well as if you're using MAGS or our guidelines calculator tool, you'll see all of those offense entries listed separately, separate entries for conspiracy, attempt, etc., to commit those more serious offenses. So you just want to make sure you're either selecting or looking to that proper offense to ensure proper guidelines calculation. So moving on to Part B, victim injury. Now, our manual goes into greater detail than what I have displayed on this slide, but in general, there needs to be reasonable proof of injury, whether it's physical or psychological, the cause of which is directly linked to the conduct of the defendant in the commission of the convicted offense. So 1 point is scored here for an injury that is non-permanent, 2 points scored for permanent injury, such as lasting muscle damage or amputation, or 2 points are also scored for death. Now, I do want to note that with regard to this particular component of the offense score, there can be some gray area. So for example, we've been asked in the past if there was a victim of a stabbing and that victim sustained a scar as a result of that stabbing, would the scar constitute a non-permanent injury or a permanent injury? And the answer is that the instructions in our manual just don't get into that level of detail. It's kind of impossible for us to cover every single scenario and injury that may occur. So that said, if there is a scenario that's not covered by the instructions in our manual, we do advise the worksheet preparer that it's at their discretion as to the number of points to be scored. And if there's a dispute between the state and the defense as to the proper number of points that should be scored, that should be brought to the judge's attention at sentencing, and ultimately the judge will make the decision as to the proper number of points that should be scored. And if the official guidelines worksheet needs to be revised, that will happen after the fact. So moving on to weapon presence. So we define weapon presence as the presence of any article or device that reasonably appears capable of causing injury, or the presence of an article that could result in the conviction under Criminal Law Article 4-101. So 1 point is scored here for a weapon other than a firearm, such as a knife or a BB gun. 2 points scored for a firearm or an explosive. So I also want to note that when calculating the offense score, a judge may include factors known to the judge when making this decision, even if they are not within the scope of the convicted offense. So for example, if a defendant was charged with armed robbery but pled to robbery, points may still be awarded for firearm or weapon presence. So before we get into Part D, special victim vulnerability, I want to generate a poll question here. We have a couple of poll questions throughout the course of the presentation. They're questions that we get pretty frequently, so we thought they'd be really good to highlight throughout the course of this webinar. So I'm going to generate a poll question in a moment here. Your answer is going to be anonymous, but we just ask you to select what you believe the proper answer to be. So would a victim who was known by the defendant to be pregnant meet the criteria for a vulnerable victim? Yes or no? So I'm going to go ahead and launch this poll. You should see it populate on your screen, and just go ahead whether you think yes or no. Again, I'll read the question one more time. Would a victim who is known by the defendant to be pregnant meet the criteria for a vulnerable victim? And we'll just give everyone a couple seconds to respond here. Maybe like 5 more seconds if you haven't yet responded. Okay, looks like we have majority here. So I'm going to go ahead and end this, and I'm going to share the results. So 79% think yes, and 21% think no. So let's go ahead and take a look at the answer. And the answer to this question is yes. Let's take a look at the factors used to determine if a victim is especially vulnerable. So 1 point would be scored for special victim vulnerability if the victim was younger than 11, 65 years old or older, or if they have a temporary or permanent physical or mental disability, including an individual who is physically or mentally limited in a material way. So the language that's noted here in red went into effect on February 1, 2021, and was added to clarify that instances in which the offender knew or should have known that the victim was pregnant, unconscious, asleep, or intoxicated are examples of temporary physical or mental limitation. And the offense score shall include 1 additional point for special victim vulnerability in these instances. So again, this was a recent update that went into effect on February 1, 2021, which is why we obviously wanted to highlight it during this webinar, that this new criteria that would constitute a vulnerable victim. Okay, so moving on to the offender score. So I talked about this when we went through that example of calculating guidelines. The offender score is a summary scale ranging from 0 to 9, which measures an offender's criminal history taking into account 4 factors. So we're going to take a look at Section A, relationship to the criminal justice system when the incident offense occurred. B, juvenile delinquency. C, prior adult criminal record. And D, prior adult parole and probation violations. So before we get into Part A, let's have another poll question here. So this is going to be a true or false. 1 point should be scored for Part A of the offender score, relationship to the criminal justice system when the incident offense occurred, if the defendant was on pretrial supervision at the time the incident offense occurred. I'm going to go ahead and launch this poll in 1 moment. Okay, and I'll go ahead and read it one more time. So true or false, 1 point should be scored for part A of the offender score, relationship to the criminal justice system when the instant offense occurred, if the defendant was on pretrial supervision at the time the instant offense occurred. Give everyone a couple seconds to respond here. Okay, let's go ahead and share these results. So 63% think true and 38% think false. So let's go ahead and take a look at the answer. And the answer is generally false. So let's take a look at the criteria. So 1 point should be scored for relationship to the criminal justice system when the instant offense occurred, if the offender was in the criminal justice system as a result of an adjudication of guilt as an adult at the time the offense was committed. So generally when someone's on pretrial supervision, they haven't yet been adjudicated guilty of that particular offense. And that's why generally pretrial supervision wouldn't constitute a point in this category. However, at one of our prior trainings, it was brought up that there could be a scenario where a person had been adjudicated guilty and still on pretrial supervision pending sentencing. And if that were the case, based on the instructions in our manual, that would constitute a point for Part A. But again, generally, pretrial supervision would not constitute that point in this category. So while we're on the topic of Part A, I just want to highlight one more relatively recent revision that was made regarding Part A of the offender score relationship to the criminal justice system when the instant offense occurred. So effective February 1 of 2020, Part A of the offender score may now differ across offenses and multiple offense sentencing events. Because it's possible the defendant was under some type of supervision at the time one of the offenses was committed, but perhaps not under supervision at the time another offense was committed. So looking back to this example that we took a look at the very beginning of the presentation, we can see that 0 points were scored for Part A of the relationship to the criminal justice system at the time this distribution of PCP offense occurred. But then a couple of months later, when the assault first degree occurred, 1 point was scored for the defendant being under criminal justice supervision. Now, if you're viewing guidelines worksheets or initiating guidelines worksheets, if there is that difference regarding the supervision status for Part A, you'll see that the 0 points as well as the individual guidelines range will correspond to the color blue, and the 1 point will correspond to the color green. So again, if you just are viewing worksheets and wondering why there's a difference in the color, it's to reflect the different offender scores. So moving on to Part B, juvenile delinquency. So 0 points should be scored here if the defendant is 23 years old or older, or if they have 0 delinquent findings within 5 years of the date of the most recent instant offense. 1 point if the defendant is younger than 23 and has 1 to 2 delinquent findings within 5 years of the date of the most recent instant offense, and 2 points if the defendant is younger than 23 and has 3 or more delinquent findings within 5 years of the date of the most recent instant offense. Additionally, I want to note that only one finding of a delinquent act, that is finding of facts sustained at an adjudicatory hearing, should be counted for a single adjudicatory hearing, meaning that if there are multiple findings of a delinquent act that relate to a single adjudicatory hearing, the individual completing the worksheet shall only include one finding of a delinquent act. And moving on to Part C, the prior adult criminal record. So aside from a few exceptions that we have noted in our manual, generally the prior adult criminal record includes all adjudications preceding the current sentencing event, whether the offense was committed before, during, or after the instant offense or offenses. On the topic of prior adult criminal record, I also just want to discuss another relatively recent update that the Commission has implemented. So effective July 2020, the MSC-CSP clarified instructions for the computation of the prior adult criminal record component of the offender score when the offender's record includes prior military adjudications. Now, when scoring the prior record, if an offender has a finding of guilt by a general or special court martial, the military adjudication shall be matched as closely as possible to the closest analogous Maryland offense. Conversely, military adjudications imposed by an Article 15 proceeding or summary court martial shall be excluded from the prior record. Further, if a military adjudication has no equivalent in Maryland law or requires as an element of the offense the defendant's service in the military force, so for example, desertion or absence without leave, that offense shall be excluded from the adult prior criminal record. And if there's a question as to the analogous guidelines offense for a military adjudication, that should ultimately be brought to the judge's attention at sentencing. So before we get into the prior record score in more detail and really break down the steps, we're going to generate another poll question here. True or false? Only one adjudication per criminal transaction should be counted towards the prior record score. So I'm going to go ahead and populate this poll question here and go ahead and select your answer. True or false? Only one adjudication per criminal transaction should be counted towards the prior record score. Give everyone a couple seconds. Looks like we're about 50% voted right now. Okay, so let's go ahead and take a look at the results. So 76% think true and 27% think false. So let's take a look at the answer here. And the answer is true. Only one adjudication per criminal transaction should be counted towards the prior record score. So since calculating the prior adult criminal record is the most complicated of the 4 offender score components, I'm going to discuss the calculation process in further detail. Now, the first step is to identify the offense with the highest seriousness category for each prior criminal transaction. Meaning, if you have multiple adjudications that stem from the same criminal transaction, you're going to identify the offense with the highest seriousness category and count that towards the prior record score. Step 2 is then to count the number of offenses in each seriousness category using only those offenses that you identified in step 1. Step 3 is then to refer to our criminal record matrix to identify the corresponding prior record level, which we're going to look to in a moment here. But before we do, I want to note that Maryland allows for what we refer to as the criminal record decay factor, meaning if the defendant has remained free of criminal justice system involvement, meaning they've been off parole, probation, mandatory supervision, etc., for 10 years prior to the instant offense, the criminal record should be reduced by 1 level. So if it was initially calculated to be a moderate, but the defendant's prior criminal history met this criteria for the criminal record decay factor, that would be reduced to a minor record. So here's a screenshot of our prior adult criminal record matrix. And let's just put all that together and walk through a hypothetical prior offender history, and then look to the matrix to find the proper level. So here we have a defendant with a prior record. Back on 10/1 of 2013, this defendant was convicted of second-degree assault, which is a seriousness category 5 person offense, where carry transport of a handgun, which is a seriousness category 7. Now, since these 2 convictions stem from the same criminal transaction, we're only going to count the more serious offense, that being the second-degree assault, which is the 5. Jumping down to 7/28 of 2016, the defendant was then convicted of burglary second degree, which is a seriousness category 4. And then on 12/12/2017, the defendant was convicted of resisting arrest, which is a seriousness category 7. Now, looking to these 3 convictions that we're applying towards the prior record score, the second degree assault, the burglary second degree, and the resisting arrest, we can see that the burglary second degree is the most serious, being the seriousness category 4. So when looking to the matrix, we're going to look to the seriousness category 4 column, and we only have 1 seriousness category 4 conviction. So we're going to refer to this first column here. And we can see that initially the defendant's record would result in a moderate record level, but then would jump to a major if combined with 2 or more offenses in categories 4 through 6, or any 6 offenses in general. So in this case would result in a moderate. So again, I understand that this is probably the most complicated component of the offender score. If you ever have questions about the scoring of the prior criminal history, please always feel free to contact our office and we're happy to walk you through that. And next, we'll just wrap up the offender score with Part D, the prior adult parole and probation violations. So 1 point should be scored here if the offender was ever adjudicated in violation of parole or probation, or was convicted of an offense while on parole or probation, unless the adjudication or conviction arose from the offense or offenses of this instant sentencing event. So jumping back to the worksheet here, the section that you see highlighted here are the recommended guidelines ranges. So when viewing the worksheet, you can see that there's space for the individual guidelines range for each convicted offense. And then down below here, the overall guidelines range for the sentencing event will be displayed. So let's take a look at a couple of examples where the overall guidelines range is adjusted due to special circumstances. So here's an example of where the overall guidelines range is adjusted due to a case involving multiple victims within a criminal event, which is often referred to as our guidelines victim stacking rule. So in this type of case, the guidelines range for each individual offense is still calculated as normal, but instead of using the highest of the upper and lower guidelines limits, again, for those of you who may remember manual calculation of the guidelines, instead, the highest of the lower limit is taken and the upper limits for each offense involving a unique victim are instead added or stacked. If there are multiple offenses that relate to the same victim, only the upper limit for the most serious offense should be stacked. So let's look at this example in greater detail. Let's say we have an individual who was convicted of 3 counts of assault second degree with 3 separate victims, each count originating out of the same criminal event. So we can see that the multiple victim stacking rule has been applied here. We can see the individual guidelines range calculated for each of those individual convictions being 2 years to 5 years. Now, again, if these didn't involve separate victims, the overall guidelines range would simply be 2 years to 5 years. But in this case, given that there were 3 distinct victims, the upper limit for each offense per distinct victim is instead added or stacked, bringing that overall guidelines range to 2 years to 15 years. So let's just recap the criteria for the stacking rule. So in order to use the stacking rule, there must be a criminal event with multiple distinct victims. There cannot be more than 1 seriousness category 1 or 2 offense. Only 1 convicted offense per distinct victim may be used to calculate the overall guidelines, and only the upper limits stack. So before I move on, let's just generate another poll question here. This is a question we get pretty frequently. So true or false, the stacking rule that we just discussed can only apply towards person offenses. I'm going to go ahead and generate that poll here. And you can go ahead and make your selection. So true or false, the stacking rule can only apply towards person offenses. Give everyone just a couple more seconds to respond. Okay, I'm going to go ahead and share the answers here. So 39% think true and 61% think false. So let's go ahead and take a look at the answer here. And the answer is false. So the stacking rule can also be applied towards property offenses as well. For example, if there were multiple victims of a theft or fraud related case, the stacking rule could be utilized in that instance as well. And again, that's a question we get really frequently. So we thought it'd be especially good to highlight during this webinar. It's a good question. So next, we thought it'd be appropriate to discuss another instance where the overall guidelines range is adjusted. So in this example, we show a case where the offender was convicted as a subsequent drug offender pursuant to Criminal Law Article 5-905. So in this example, the offender was sentenced for distribution of cocaine, a Category 3B offense. If the offender had an offender score of 3, the range in this example would have been 3 years to 7 years. However, because this offender was convicted of a subsequent drug offense pursuant to Criminal Law Article 5-905, under that statute, the statutory maximum doubles, and by guidelines rule, the guidelines range for that offense would also double, meaning that it would increase to an overall guidelines range of 6 years to 14 years. So again, just another instance we wanted to highlight where the overall guidelines range is adjusted due to this enhancement. So next, we're just going to wrap up the last few sections of the worksheet here. The information that you see highlighted on this slide is victim information. So these questions pertain to the rights of victims at sentencing. The Maryland State Board of Victim Services has asked us to collect this information. So we encourage practitioners to answer as many of these questions as possible, just to ensure that we're getting as much data regarding the answers to these questions as we can. The remaining fields that you see highlighted here, these are the sentencing and departure related fields that are typically completed by judges and his or her designees post-sentencing. So these fields, for example, include sentence information for each individual offense, the disposition type, whether victim court costs were imposed, etc. But there are two specific fields located in the section that I wanted to emphasize further, those being corrections options and other alternatives to incarceration that you see highlighted here. Now we're going to talk about corrections options as they relate to guidelines compliance in a moment here, but just to quickly sum up, sentences involving corrections options program, for example, drug court, home detention, they factor into guidelines compliance. Again, we'll talk about this in a little bit. But that being said, it's important to make sure that those programs are being accurately reflected on the guidelines worksheet since they do factor into guidelines compliance. Now below that field, you'll see this question asking, was the offender sentenced to some other alternative to incarceration? This field captures other programs that do not meet the criteria for corrections options, but are still utilized by judges as other alternatives to incarceration. So these include outpatient substance abuse or mental health, as well as standard alternative programs such as anger management. And capturing these programs just allows us to collect more detailed data that, in combination with recidivism data, may be used to help identify effective and promising alternatives to incarceration and to help inform future sentencing decisions. So again, important to make sure that those programs are reflected accurately on the worksheet. So next, we're going to move the discussion into guidelines compliance sentences. Now, a sentence in which the sum of incarceration, credited time, and home detention time falls within the applicable guidelines range is deemed a guidelines compliance sentence. So generally, suspended time is not considered when determining if a sentence is compliant. The one exception being sentences involving corrections options, which we'll talk about in another slide. But generally, suspended time doesn't factor into guidelines compliance. Now, the overall guidelines applicable sentence is compared to the overall guidelines range for the sentencing event in order to determine guidelines compliance. There are a few qualifiers to consider regarding guidelines compliance. The first is that sentences adjudicated pursuant to what the guidelines formerly referred to as American Bar Association or ABA plea agreements are guidelines compliant. And on the next slide, I'm going to explain why I said formerly referred to as ABA pleas. Now, this ABA compliance rule was initiated based on feedback received from the judiciary that binding pleas represent a consensus of the parties and the court within their specific community. Accordingly, the commission felt it was important to define these as compliance sentences. So I just want to take a moment to briefly describe binding pleas. Binding pleas are three-party agreements in which the defense and the state present to the court on the record an agreement that incorporates a specific sentence. And if the judge accepts that agreement, it is binding on the court pursuant to Maryland Rule 4-243. In recent years, we've had multiple petitioners contact us inquiring as to what exactly constitutes an ABA plea, and in particular to ask about the level of specificity that is required for a plea agreement to be considered an ABA plea. So due to the frequency of questions surrounding the definition of an ABA plea, the Commission studied this issue during the course of 2020. We reviewed definitions of binding plea agreements from other jurisdictions, examined relevant Maryland case law, and analyzed data on sentences for guidelines eligible cases sentenced from 2017 through 2019. And informed by this review, the Commission at its December 8, 2020 meeting agreed that the term ABA plea agreement is not universally known and should be replaced with the more intuitive MSCCSP binding plea agreement. Further, the Commission adopted proposed revisions to the definition of an MSCCSP binding plea agreement to emphasize that a binding plea involves agreement from all three parties and to confirm that the court maintains the discretion to accept or reject the plea. And finally, the Commission adopted language to clarify that an MSCCSP binding plea agreement means an agreement to a specific amount of active time, if any, not merely a sentence cap or range. And the Commission believes that this revised definition will bring greater transparency to guidelines, compliance sentences, strengthen public trust, and provide more uniformity in understanding what types of pleas are guidelines compliant. So these revisions that you see here on this slide will be going into effect on April 1 of 2021. So in sum, I'm just going to read the definition of what an MSCCSP binding plea agreement will entail. That being a plea agreement presented to the court in agreement by an attorney for the government and the defendant's attorney or the defendant when proceeding pro se, that a court has approved relating to a particular sentence and disposition. An MSCCSP binding plea agreement means an agreement to a specific amount of active time, if any, not merely a sentence cap or range. The court has the discretion to accept or reject the plea. The agreement is binding on the court under Maryland Rule 4-243 subsection C if the court accepts the plea. So I know that was a lot to probably digest. Let's do a summary of all of these updates regarding guidelines compliant pleas that will be going into effect on April 1, 2020. So the court may still agree to a binding plea pursuant to Maryland Rule 4-243 subsection C. This is not changing anything relating to the Maryland rule. These changes going into effect on April 1 of 2021 are stating that only specific binding pleas, which will be Maryland binding, or I'm sorry, MSCCSP binding pleas will be considered guidelines compliant. And that an MSCCSP binding plea agreement must include an agreement to a specific amount of active time, if any, not merely a sentence cap or range in order to be considered guidelines compliant. So let's just do one more poll question, kind of taking all of that information and putting it towards a real life sentencing scenario. So let's say in this scenario, the guidelines for the sentencing event are 2 years to 4 years. The state and the defense present to the court a plea agreement to a sentence range anywhere from probation to 2 years. The court accepts this agreement and sentences the defendant to 3 years, suspend all but 1 year. Is this an MSCCSP binding plea agreement? So I'm going to go ahead and generate this last poll here. Now the question is going to be cut off. We weren't able to fit all of the text, so let me reread the scenario as you all are answering. The guidelines for the sentencing event are 2 years to 4 years. The state and the defense present to the court a plea agreement to a sentence range anywhere from probation to 2 years. The court accepts this agreement and sentences the defendant to 3 years, suspend all but 1 year. Is this an MSCCSP binding plea agreement? Give everyone a couple seconds here. Okay, I'm going to go ahead and share the results. Okay, so 18% think yes and 82% think no. So let's go ahead and take a look at the answer. And the answer is no. So as a reminder, an MSCCSP binding plea, it must involve an agreement to a specific amount of active time, if any, not merely a sentence cap or range. So in this scenario, the court accepted a plea agreement to a sentence range anywhere from probation to 2 years, which is why it would not constitute an MSC CSP binding plea agreement and therefore would not be deemed guidelines compliant. So just to wrap up, other scenarios that count towards guidelines compliance, that being sentences to corrections options program. So sentences to a corrections option program is deemed guidelines compliant, provided that the initial sentence plus any suspended sentence. So essentially, as long as the total sentence falls within or above the applicable guidelines range, and the case does not involve a crime of violence, child sex abuse, or escape, it would be deemed guidelines compliant. So let's take a look at the list of corrections option. So I just want to note that the commission actually has expanded the alternatives to incarceration that qualify as corrections option. So this expansion of designated corrections options has allowed judges to utilize a broader range of alternatives to incarceration while still remaining compliant with the sentencing guidelines. So previously, corrections options included those that you see listed in black text here, that being home detention, inpatient or residential treatment, inpatient drug or alcohol counseling under Health General Article or drug court. And then effective July 1 of 2019, this list was expanded to also include participation in problem-solving courts, for example, mental health court, veterans court, required substance abuse treatment for the possession, administration, obtainment, etc. of CDS, work release, or weekend or other discontinuous incarceration. And then wrapping up guidelines compliance sentences, sentences in which the offender received credit for time served with no post-sentence incarceration time. If that amount of credited time exceeds the guidelines range, it's deemed guidelines compliant. So for example, if the guidelines range is probation to 3 months and the sentence is 6 months fully suspended with credit for 100 days, the sentence is still compliant even though the credit for time served exceeds the upper guidelines limit. Okay, so we're nearing the end of the presentation now, and I just wanted to quickly talk about the guidelines worksheet completion process. I'm sure many of you are probably familiar with that process, but we thought it'd still be good to highlight. So beginning with Criminal Procedure Article 6-216, it indicates that the court shall consider the guidelines at sentencing. And in order to do so, a sentencing guidelines worksheet must be prepared. Criminal Procedure Article 6-210 then requires the Sentencing Commission to collect sentencing guidelines worksheets, automate the information, and monitor sentencing practice. Now, many of you are probably aware of our Maryland Automated Guideline System, commonly referred to as MAGS, but this is our web-based application that permits the electronic completion and submission of sentencing guidelines worksheets. So it's now been deployed in all 24 jurisdictions. So all 24 jurisdictions utilize this system to initiate and submit guidelines worksheets. Now, for those of you who may not be entirely familiar with the process, generally, state's attorneys, the Office of the Maryland State Prosecutor, Office of the Attorney General, or parole and probation agents when a pre-sentence investigation is ordered, they are the ones who are officially initiating worksheets in the MAG system. And then post-sentencing, typically judges and their designees, such as law clerks, court clerks, administrative assistants, they are going in and entering sentence information and submitting the guidelines worksheets through the system. Now, all that said, defense attorneys have read-only access to the worksheets in the system. This is just to avoid an issue of duplication. If there were multiple parties able to access the system and officially initiate guidelines worksheets for the same defendant, if there were discrepancies in guidelines calculation, it would be very confusing for judges and their designees to figure out which one to ultimately submit. So that said, if you log into our system, view how state or parole and probation initiated guidelines worksheet, perhaps for those defense attorneys we have here on the webinar, if you don't agree with the calculation, we certainly encourage you to calculate your own sample sentencing guidelines and bring that discrepancy to the judge's attention at sentencing. And as I mentioned earlier, once the judge makes the decision, if any changes need to be made to the official guidelines worksheet, that should be done before the worksheet's ultimately submitted. For any private defense attorneys that we may have here on the webinar training, To obtain a MAGS account, we just ask that you send us an email to our general email account, which I'll give you at the end of the webinar here in a moment. And you would need to provide your full name, your client protection fund number, and the address you use to register with the client protection fund. And then based on that information, we'll generate a MAGS account for you and send you back a MAGS username and password so that you can access the system and have that read-only access to the guidelines worksheets. I also want to point out our guidelines calculator tool. Now, our guidelines calculator tool is a standalone tool that can be utilized by anyone to calculate sample sentencing guidelines. So you don't need a user ID, you don't need a password to access it. The only caveat is that the information that you enter into the guidelines calculator tool, it's not saved or stored for a period of time. So you'll want to make sure after running those guidelines that you're either saving the PDF to your computer or printing out a copy of that worksheet to take with you at sentencing. So here's a screenshot of what our guidelines calculator tool looks like. These first three tabs that you see, offender information, offender score, and list of offenses, those are the tabs that are completed prior to sentencing. And the guidelines calculator tool mirrors MAGS. So all of this information that you see in the guidelines calculator tool, it's the same information that the state, parole and probation, et cetera, are using to calculate the guidelines in the MAGS system. I know that we're running a little short on time. I am going to do a demonstration of this guidelines calculator tool for those of you who are able to stick around for a couple more minutes. I just have like 2 more slides and then I'll jump into this demonstration. So if you're able to stick around, we certainly encourage you to do so. I know that this is an extremely helpful tool, especially for defense attorneys that they can use to calculate their sample guidelines. And here's a screenshot of what that worksheet generated using the guidelines calculator tool would look like. It's an exact replica of our sentencing guidelines worksheet. The only difference being at the lower right-hand corner, it just says version guidelines calculator tool. So you know that it was generated in the guidelines calculator tool versus MAGS. Now, since the guidelines calculator tool and MAGS mirror each other, I know I'm going to do a demonstration here in a moment, but if you ever want a more thorough instructional video, please check out our MAGS instructional videos. There's 2. The first one is geared towards state's attorneys, parole and probation agents, defense attorneys. It shows you how to initiate a worksheet in the system. The second one's geared towards judges and their designees, which focuses on entering sentence information and submitting the worksheet. So if you have questions about the guidelines calculator tool and how to properly initiate information using that tool, definitely check out the first MAGS instructional video, again, because they mirror each other. Okay, so next I just want to briefly highlight some of the recent and upcoming anticipated work of the Sentencing Commission. So the first activity I want to highlight is the Commission's training for the revised definition of a guidelines compliant plea that will be going into effect on April 1. We will be continuing to conduct webinars throughout March for judges, court staff, and other criminal justice practitioners to help get the word out about these changes. And again, just to highlight other recent updates similar to what we discussed throughout this training today. So if you have a colleague who wasn't able to make the webinar today, if they check out our training page, you'll see that we have a couple of general practitioner webinar trainings, as well as some that are geared specifically towards judges and their designees coming up in March. So they can definitely register for those. Next, I just want to highlight that the Commission will be conducting the next scheduled cell-by-cell compliance analysis in early 2021 to review the guidelines ranges in the 3 matrices to consider whether any should be amended. So this cell-by-cell analysis was originally scheduled for 2018 to 2019, but it was postponed due to the passage of the Justice Reinvestment Act, which resulted in a lot of changes for the maximum penalties and their corresponding guideline seriousness categories for many of the drug and property offenses. So this year in 2021, we'll have 3 years of post-JRA data to conduct this analysis, and the guidelines ranges may be amended to reflect recent sentencing trends. Also, in response to an issue that was noted in a survey that the Commission distributed in May 2020 that was used to solicit feedback from the criminal justice community, we will also be reviewing the prior adult criminal record component of the sentencing guidelines offender score to assess the impact of minor misdemeanor and traffic offenses, including nuisance or quality of life offenses such as disorderly conduct, trespassing, and public public intoxication, marijuana possession, as well as traffic offenses. And then finally, we will be conducting a review of distribution and possession of child pornography and sexual solicitation of a minor offenses, along with a corresponding review of instructions for scoring victim injury points related to internet crimes against children. So we agreed to conduct this review in response to feedback that we received at our 2020 public comments hearing. So just to say, if you ever have any feedback or concerns that you would like to address to the commission, we hold a public comments hearing every year in December. So we certainly encourage you to register for that towards the end of the year if you have anything that you would like to address the commission. You can also feel free to reach out to any of the commissioners who serve on our commission, and they can bring forth any of your concerns, and also feel free to contact our staff. And finally, I just want to note that we're also working on redesigning our website to make it more mobile friendly, and we hope to deploy an updated version within the next couple of months. So stay tuned for that. And just to wrap up, I just want to highlight a couple of commission resources. The MSCCSP is continually updated throughout the year, and it's a really useful resource for individuals who implement the sentencing guidelines. So our main website's www.msccsp.org. We have all of our various annual reports, our guidelines e-news, which helps to keep practitioners informed about recent changes to the guidelines. If you don't subscribe to our e-news but would like to, please just send an email to our general account asking to be added to the guidelines listserv so you can stay informed about changes to the guidelines. And more recently, we just started producing a series of topical mini reports titled Sentencing Snapshot, intended to provide a quick review of sentencing trends and other topics of interest. So here's a screenshot of our most recent issue of the Sentencing Snapshot, which provides a closer look at felony, narcotics, and hallucinogen offenses in Maryland circuit courts. So all of the issues of our Sentencing Snapshot are available on our website. I have to give a shout out to my colleague, Sarah Bowles, who takes the lead on developing these snapshots. She does a great job. We've received a lot of positive feedback regarding the snapshots. So again, feel free to check those out. Our website also provides, also has our Maryland Sentencing Guidelines Manual and Guidelines Offense Table available in PDF format, and also provides access to MAGS and our Guidelines Calculator tool. We also have some instructional videos and guidelines training webinars available. Here's a screenshot of our training page. Just want to point out under resources, we have a sentencing guidelines training video that was conducted back in August, which is very similar to what we conducted today. If you ever want a refresher for guidelines training, and then following these upcoming webinars that we have in March, we'll be posting an updated version to our YouTube video, or YouTube channel rather. So if you go to YouTube and just type in MSCCSP, you'll be able to see our uploaded videos there. Also, feel free to contact our help desk or email us at msccsp@umd.edu. So this concludes the webinar. I'm going to jump into the demonstration of the guidelines calculator tool, which I'll keep it brief. I'll make it like 5 to 10 minutes. But before I do that, I just want to ask Dave, do we have any outstanding questions or anything that we want to address before those who really have to jump off can jump off?
Yeah, that's good. So there's a couple questions about the guidelines calculator tool, which I'll leave off because I think you'll be addressing them in the demonstration. We also had a question about whether there is a source of information for determining a defendant's prior convictions besides case search that's available to defense attorneys. I don't know that there's the answer I think is unfortunately no for defense attorneys, other than to get the information from the prosecutor.
That's my understanding. Any other questions?
No, there's no other. There was some that we've addressed in the chat room, Catherine, but I think those have been addressed thoroughly. But certainly willing to entertain other questions or at this point.
Yeah. Does anyone have any questions, outstanding questions that maybe haven't been asked? We can take, like 1 or 2 before jumping into the demonstration. No. Okay. Okay, well, for those of you who have to hop off, thank you so much for joining us today. If you're able to stick around, let's go ahead and jump into this demonstration of the guidelines calculator tool. I'm just going to go ahead and get that set up. So give me 1 second to close out of this presentation here.
Maybe I think maybe while Catherine's bringing that up, one point of confusion it seems maybe in the chat room that I'll just speak to briefly is a couple questions about whether private criminal defense attorneys can get access to mags, and I did address that in the chat room, and the answer is, yes. One of the things that we clarified is that criminal defense attorneys have essentially read-only access to the worksheets as they've been initiated. And that is done purposely because the state really is the party that's responsible for initiating the guidelines, really needs to do that because they have the access to the criminal history records, which was just brought up. But also we worked strongly off of advice on when we developed this automated system. We were strongly encouraged to not allow for duplicate worksheets to be created, and the hectic issue that would arise if duplicate worksheets were being initiated for the same defendant for the same sentencing. So the system, the way it's set up really right now, replicates how it was done with the paper worksheet, in that the state, initiates the guidelines. The defense should calculate their own guidelines. They should make sure they understand the guidelines. And the easy way to do that is the guidelines calculator tool, as Catherine is about to demonstrate. If you have a discrepancy with the way the guidelines are calculated, you can bring that forward to the judge. And so I just kind of wanted to address that because that was something that came up in the chat room.
Great. And Dave, can you just confirm you're seeing the guidelines calculator tool?
Yeah, it looks good.
Okay, good. Okay, so here's the guidelines calculator tool, and you would simply just click this proceed to guidelines calculator tool button. I don't know why it keeps doing that. Let me go back. It's taking me to mags. Okay, here we go. So then it's going to bring you to the guidelines calculator tool. Now this first tab here, the offender information, captures basic demographic information about the offender. You can enter as much or little information on this tab as you want. You'll see when I get to the offender score tab that the required fields are marked with red asterisks. So I'm just going to go ahead and enter like a John Edward test, and let's just go ahead and make this Anne Arundel County. And then I'm going to go ahead and click next to get to the next tab. So this is the offender score tab. I mentioned earlier, part A, relationship to the criminal justice system when the instant offense occurred, how that can vary in multiple offense sentencing events. So that's actually scored at the offense level. And when I get to this list of offenses tab and add convicted offense information, you'll see how I score it there. So you would then just make selections with regard to juvenile delinquency, prior adult criminal record. If you hover over this, I just want to note that this is a clickable link that brings you to our prior adult criminal record matrix. So I'm going to go ahead and make this a moderate. And then if you wanted to apply that criminal record decay factor that we talked about, you could click that. And you can see once I click yes, jumps from a moderate to a minor. And when you view the worksheet, it actually shows that the decay factor was applied. And then finally, prior adult parole and probation violations. Now, we certainly encourage you to utilize these information icons. You'll see them throughout the guidelines calculator tool. If you click the icon, it gives you more detailed explanations of what we're trying to capture in each particular field. And all of this information is taken directly from our manual, which is nice, so that you don't have to go looking up another resource. So again, any questions, certainly utilize these information icons. So there's the offender score tab, and I'm going to jump to this list of offenses tab. Now, jumping back to the very beginning of the presentation when we talked about sentencing events, when you have multiple criminal events, which are often indicated by their unique case numbers and dates of offense, if they're being sentenced before the same judge on the same day, they constitute one sentencing event, and therefore one set of sentencing guidelines should be completed for them. So even if you have unique case number information between those criminal events, you're going to want to enter all of that information on this list of offenses tab. And I'm going to show you how to do that. In this example, I'm going to enter information for 2 separate criminal events to show you what that would look like. So begin, you're simply going to click add offense. which is going to bring you to the offense offender score screen. So beginning in the upper left-hand corner here with event number, I talked earlier how you want to make sure you're entering the proper criminal event number when inputting this convicted offense information. So I'm going to start with criminal event number 1, and this is going to be the third count in the indictment. I'm going to enter an offense date of November 1st of 2020. And you can see based on the jurisdiction that I selected on the offender information tab that this guidelines calculator tool is going to pre-populate the case number format based on the jurisdiction you selected. So it's pre-populating C02CR, which corresponds to Anne Arundel County. Following that, I'm going to enter the 2-digit filing year, and then there needs to be a 6-digit sequential number. So I'm going to enter 4 zeros, 1, 2, 3, 4, and then a 1, 1 to complete that case number. To reflect it in its proper MDEC format. So no dashes, this is how you would want it reflected. Now to search for the convicted offense title, you can search 2 ways. You can click this most common offenses button, which will bring you to our 25, where is this? Whoops. Our 25 most common guidelines eligible offenses. Oh, I'm stuck. Okay. Or you can click search, which is going to bring you to our general offense table. There are a couple of different ways you can narrow down the search. You can either enter offense title information, the CJIS code, the statute, or the type, whether you want to narrow it by person, property, or drug. Or you can utilize the search feature to simultaneously search all of those columns. So for example, if I wanted assault, second degree, I'm just going to type in assault, and then we can see any offense that contains the word assault is going to populate here. And I'm just simply going to click select next to assault second degree. Once I do that, the seriousness category, CJIS code, statute, and statutory maximum, if there were a mandatory minimum, that would populate here. We talked earlier about how any attempt, conspiracy, solicitation, how it's assigned the same seriousness category as the underlying offense. So you would simply select the underlying offense, and then let's say this involved an attempt. You would go ahead and just select that radio button, with the exception being for those more serious offenses. And I'm just going to quickly show you, if you were running guidelines for a murder case, for example, you can see how we have separate entries for attempt, conspiracy, solicitation. So that's how you would want to make a selection involving attempt, conspiracy, or solicitation.
Catherine, one point to point out there would be that if you selected murder and then tried to select attempt or conspiracy, those buttons would be grayed out. So that's your hint,
Yes.
right? You couldn't select those radio buttons. So that's your a hint that, oh, there's a separate seriousness category for attempted first degree murder or solicitation of first degree murder.
Yes. And then jumping down to enhancements, if you just click on this drop down, so these are various enhancements that can be applied, that being the subsequent drug offense and range doubling enhancement we talked about. If the defendant's convicted of a subsequent crime of violence and subject to a 10, 25-year or life mandatory minimum, or if they're a repeat sex offender and subject to a life maximum, as long as the underlying offense would enable or allow for one of those enhancements to be applied, you'd see those enabled here. And then to flag an offense for the multiple victim stacking rule, you would just select this yes radio button to apply that rule that we talked about. So I'm going to jump down here to offender score. We can see that sections B, C, and D pre-populate based on what you already selected on the offender score tab. And I would simply just need to make a selection with regard to part A. So let's go ahead and plug in 0 points. Once I do that, the tool is going to generate and calculate that overall offender score for you. Now, assault second degree is a person offense, so I'm going to be prompted to calculate the offense score. What's nice is that the tool, as well as MAGS, it's going to calculate part A for you just based on the seriousness category of the underlying offense. So I can see 1 point was scored given that this is a seriousness category 5 offense. And I'm just going to make selections regarding victim injury, weapon presence, and special victim vulnerability. And then similarly, the guidelines calculator tool calculates the offense score. And you would simply just click calculate guidelines range. It would then calculate the individual guidelines range for the offense, as well as the overall guidelines range for the sentencing event would be displayed here. So I'm just going to click save this page and close. And you can see once I do that, here's all my convicted information for the assault second degree. So I'm just going to quickly add one more offense. This is going to be a possession of cocaine that occurred a couple of months later. It has its own unique case number, and I'm going to make it criminal event number 2, since it is being sentenced on the same day as this assault second degree. So I'm going to click add offense, make sure this is criminal event number 2, and let's say this is the second count. And let's say this occurred a couple of months later on 1/1 of 2021. So this has a different case number, say 1-1-1-2-3-4-2-2. I'm going to go ahead and click search, and I'm just going to search for the term cocaine. And this is the one I want here, the CDS possession cocaine first offense. I'm going to click select. I'm going to jump down to the offender score. Let's say there were 0 points here. Now this is a drug offense, so I'm not prompted to enter anything for the offense score. I can simply jump down and just click calculate guidelines range, which again will generate the individual guidelines range for the offense and the overall guidelines range for the sentencing event. So I'm going to click save this page and close. And there I have both my criminal events with my unique case numbers, their individual guidelines range, and then the overall guidelines range populating at the bottom here. Now, if you're running sample guidelines, maybe you've entered a couple of convicted offenses and you want to delete some of them. To do that from this tab, you would simply just click this trash can icon. If you want to make edits to any of the convicted offenses you entered, just go ahead and click on this edit icon. It looks like a pencil, and it'll bring you back to this screen, where you can change around scoring, offense scoring, or, change the convicted offense, whatever you may need to. And then to view the worksheet, you would simply click this View Worksheet PDF button in the lower left-hand corner. And as I mentioned earlier, it's going to give you that exact replica of the sentencing guidelines worksheet, noting that the version is guidelines calculator tool. I mentioned at the very beginning, each separate criminal event should correspond to their own worksheet. So again, even in this test scenario, there was one convicted offense per criminal event, but based on how I entered that information, they still correspond to their own separate guidelines worksheet, which is correct, but there's still one overall guidelines range of probation to 1 month calculated between them. So I hope that demonstration was helpful. I know it was pretty brief. Again, you can check out our MAGS instructional video that will go into a little more detail about initiating worksheets, but you can also feel free to contact our office. But again, I know it's a helpful tool, so it's something we definitely wanted to highlight for you all during this webinar. So that said, Dave, is there anything else that we want to address before we conclude today?
No, I think that's it. There was one individual who had indicated they had some additional questions. It looks like they plan to ask them in the chat room, or if they wanted to jump on now and ask them, that's fine. We can, Brian and Angela, if the staff could stick around and answer questions. If anyone wants to jump off, we can answer them in the chat room to finish up.
People can unmute themselves too at this time.
Yeah, if there's any outstanding questions for any of the participants, feel free. Okay.
Someone's giving us the clap, clap, clap.
Okay.
And I agree. That was a tremendous presentation. Thank you, Catherine. That was a ton of information packed into a relatively short amount of time.
Great.
So thank you, and thank you, David, and also a shout out to Stacy and Sarah for diligently working behind the scenes in the chat room to answer all those questions. Thank you, and thanks to everyone who registered and attended the training today. I look forward to seeing all of you out in the real world sometime soon. I wish you all good health and stay safe out there. And thank you again to our presenters today.
Well, we appreciate the opportunity to speak with this group. Thank you, Brian and Angela, again for setting it up.
Yes,
Thank you so much.
Thank you again, Angela. Okay. Take care,
We're good.
everyone.
Okay.
Bye.
Bye.